May I please, Lordship? Lordship, I beg to mention item number 10. Lordship, here I'm yet to complete my affidavit. So 2 weeks' time may be granted.
2 weeks.
2 weeks.
Lord Leonard, additional AG, Mr. M. Timson, who prays for 2 weeks.
2
2
weeks.
weeks' time to file the affidavit in opposition on behalf of the state respondents. Stop. Prayer is allowed. List after 2 weeks. Leonard Counsel for the petitioner, Ms. Esther is present.
Lordship, interim passed in the IA as well as the writ petition may be continued.
The interim orders passed earlier in the
IA 81.
IA also.
Yes, Your Lordship.
In IA 81 of 25 and in the writ petition shall continue till the next date.
Much obliged.
May I please, my lord?
Yes.
Lordship, I beg to mention hearing item number 18. Lordship, because of some parted matter in court number 1, I have some difficulties to take up this matter today, Your Lordship.
18?
Yes, if this... It can be listed after a week, my lord.
After heard Learned Counsel for the state respondents, Mr. N. Angami, Senior Government Advocate, who prays for a week's time as he has some difficulties today. Prayer is allowed. Learned Counsel for the petitioner is present. List after 1 week.
Deeply obliged. Lordship, I beg to mention item number 16, Lordship.
16.
Yes. Lordship, if this item may come out after 2 weeks, Lordship.
It's a fixed matter. Otherwise.
If the leading counsel is indisposed.
Learned Counsel for the petitioner, Mr. Cheng Mei Kongyak, submits that the leading counsel, Mr. Joshua Sheki, is indisposed.
Your Honor, it's Nika Aye.
Oh, okay.
She's taking up the case.
That Learned Counsel Nikai is indisposed today and accordingly prays for
2 weeks.
2 weeks' time. Learned Counsel, Learned Government Advocate has no objection. List after 2 weeks.
Obliged, Lord.
Please, Lordship.
Yes.
Lordship, beg to mention item number 7. Make a mention on, make a mention on behalf of my senior who has been recently appointed as a legal aid for the respondent number 3, the victim. So if some few times may be granted, Lordship, some few days. 2 weeks' time, Lordship.
Who's the counsel? Who has been appointed?
Officer 40.
Fuseko.
Yes.
It is submitted by Learned Counsel, Mr. Yes.
Subsequently, the respondent number 3 has is certainly to represent the complainant. So,
Oh, acha. Because nobody was appearing, that's why the court had appointed
in
the
fact, the
amicus.
formal notice we are yet to receive it yet.
So,
Okay.
which one?
Okay.
Item number 7.
Learned Counsel, Mr. Rainbow, is delete the previous one, has stated that he has received instructions to appear on behalf of the respondent number 3. Yes, and prays for 3 weeks' time to file his Bagratnama as well as objections, if any. Accordingly, prayer is allowed. The name of Mr. Fuseko may be deleted as amicus curiae, as the respondent number 3 has already been represented. Stop. Learned Counsel for the petitioner has no. Who's for the petitioner?
Senla Kumar, I think she's not present today, Lordship.
Petitioner is not present when the matter is called. Stop. List of the 3 weeks. Yes.
Lordship, I can beg to mention item number 21, Your Lordship. Item 21. Here, the leading counsel, Sir P.B. Paul, is indisposed today, Your Lordship. So if this matter can be
Who is
listed up.
indisposed? Baby Paul.
Yes, Lordship. So if this matter can come up on Monday.
Learned Counsel, Mr. M. Verona,
Lordship, M. Verona.
prays for listing the matter on
Monday.
on behalf of Mr. P.P. Paul, who is indisposed. Stop. Learned Government Advocate is present and has no objections. Place the matter on 11th August. Yes.
Lordship. Lordship, there's an interim, Lordship.
The interim order passed earlier shall continue till the next date.
Lordship, I can beg to mention item number 20 on behalf of Young Gauhati CCC. Lordship, this is indisposed today, Lordship. So if this matter can come up after 1 week, Lordship.
Well, let it be on Thursday, 14th.
14th.
Lordship, Lordship.
Learned Counsel, Mr. M. Firo has made a mention on behalf of Young Gauhati, Learned CGSE, who is indisposed today. Learned Counsel prays for listing the matter on 14th of August. Stop. Learned Counsel for the petitioner, Mr. N. Longkamar, has no objections. List accordingly. 14th.
Not obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 9.
9. Yes.
Lordship, my learned counsel is unable to appear due to his personal reason. So it is on humble prayer that 1 week time may be given to us.
You are mentioning on behalf of
Sir Ilivil Zhao.
David Zhao.
Yes, Your Lordship.
Learned Counsel for the petitioner. Your name?
Chigovilla.
Villa has made a mention on behalf of the leading counsel, Mr. Ilivil Zhao, to list the matter after
1 week time.
1 week, as Mr. Ilivil Zhao is indisposed. Stop. Learned counsel for the
sole respondent.
sole respondent is present and has no objections. List the matter after 1 week. Yes.
Much obliged.
This is Lordship. Lordship, I beg to mention item number 17 on behalf of Visual Mummy Lordship. I'm here to receive instructions, so can you grant me 3 weeks time, Lordship?
On behalf of,
Lordship?
you are mentioning on behalf of
On behalf of Visual Mummy
Visual Mummy.
Lordship.
1 week,
3 weeks,
3
Lordship.
weeks,
Lordship.
to file a counter, or it's already filed.
We have already filed, Lordship, but since
Yes.
respondent number 6 has been impleted, Lordship.
On the last occasion,
Yes.
the respondent, but the newly implemented respondent, they sought time to file an affidavit. Respondent number 6.
Okay. So, filed, already filed. Respondent
not-
number 6, not yet. Learned Counsel, Learned Government Council has submitted on behalf of Mr. V. Jimomi, who is appearing the matter, to list the matter after 2 weeks. 2 weeks, as he has some personal difficulties today. Stop. In the meantime, the newly implemented respondent number 6, who's appearing?
I'm for respondent number 5.
Okay. Respondent number 6. No one is appearing.
State.
Oh, okay,
Yes,
okay, okay,
Lordship.
state.
Newly implemented,
Then
Lordship.
the delete, yeah. Learned Counsel, Mr. Chingmei Kongyak is present for the respondent number 5. You have filed your affidavit?
Yes.
Okay. So accordingly, list the matter after 2 weeks.
Lordship.
Presence of the petitioner, counsel also. Just Learned Counsel for the petitioners that is such present. Yes.
Please, my lord. Lordship, I want to make a mention for tomorrow. An item which was supposed to be listed today. One bail application, the last order.
Bail.
Yes. It was on the last occasion. It was directed to be listed after 2 weeks. So 2 weeks lapsed on Wednesday. But today I was expecting it to be listed. There is urgency in this case since it's a bail matter. If it can kindly be listed tomorrow. This is a mentioned memo.
Let it come up on Monday.
Monday? My
Monday.
lord, my lord.
Because tomorrow we have some difficulties.
My lord.
Last day, no? Monday, okay?
I'll submit the mentioned memo to the
Yes, yes.
bench assistant. Deeply obliged. Lordship, I have a prayer for hearing item 14. This is a consensus prayer. If it can kindly be listed after 4 weeks.
On the prayer of the learned counsels for the parties, list the matter after 4 weeks for hearing.
Deeply obliged.
Yes.
May I please,
Yes.
Your Lordship? Lordship, I beg to mention item number 15. Lordship, I'm the appellant, appearing on behalf of my colleague, Treketono. Please grant me 3 weeks' time, Your Lordship.
On what ground?
I need some more time for preparation, Your Lordship.
Learned counsel, such and such, makes a mention on behalf of the leading counsel, Miss Kriki Tonyo, to list the matter after 3 weeks.
Lordship.
After 3 weeks, as he needs further preparation in the matter. Learned Government Advocate, Mr. K. Angami, has no objections. list of the 3 weeks.
Bless your lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 6 and 8. Your Lordship, we have
Item?
filed 6 and 8.
6 and 8.
Yes. We have filed for leave for absence. However, it is reflected in the post list. And as such, it is my humble prayer that the matter be listed on 18th of August.
You're mentioning on behalf of?
BN Sharma, respondent.
Or BN Sharma?
Yes.
Yes. Item 6 and 8.
My lord,
please.
18 August, I'll have some difficulties. So if this can come up after 3 weeks, I'll be out of
Learned
session
Counsel?
on 18.
Learned Counsel, Mr. Your name?
No, Becky here. MK here.
Makes a mention on behalf of Mr. B.N. Sharma to list the matter of the 3 weeks, as Mr. Sharma has already filed his letter of absence before the registry of this court. Stop. Learned Counsel for the appellant, Mr. Takakichu, is present. List the matter of the 3 weeks.
Obliged, my lord.
Yes.
Much obliged, Your Lordship.
8 also, my lady?
Yes.
8 also? It was
Yes,
6
yes.
and 8.
6 and 8, isn't it? Yes. Yes, 6 and 8. After 3 weeks.
For motion, item number 1.
My Lord, I am appearing on behalf of the petitioner. My Lord, at the very outset, I am praying for an unconditional apology for any mistake I may commit during my pleading, my Lord. I am not aware of the court craft of this court. I am coming from the Calcutta High Court. So please excuse me for any mistake that I may make.
What mistake? What happened?
I may make during the course of my pleading.
No, it's all the same. Everywhere it's the same.
My Lord, there are twofold allegations that has been made out against this particular petitioner, Joydeep Datta. They have claimed, the de facto complaint had stated that he has been selling forged lottery tickets to one Akshay Prakash Salonke. Another set of allegations that has been made out by him is that he had bought 2 lottery tickets after the draw. Those were the 2 winning lottery tickets. So these are the 2 allegations that has been made out against him, for which the prosecution has brought out this, taken out this FIR under section 464, 465, 468.
This seems to be a racket. Or the other day also, I remember a similar case came up.
Yes, yes.
Isn't it?
Yes.
Fake lottery ticket
Yes,
and
yes.
fake winning ticket.
I shall assist
Yes.
my lord in this regard.
Yes.
So
There are many accused in this matter.
there are 3 accused persons. I am only representing Joydeep Datta, who is before the Honorable Court today. Now the section that has been leveled is 464, 465, 468, read with section 34 of Indian Penal Code. Now my lord, let us go to the sections first.
Okay. Koza, IPC. IPC.
The allegation that has been made out is 464. So primarily what is 464, my lord? 464 states about making a false document. So there has to be a existence of an original document. There is a counterfeit of that original document. Otherwise we cannot claim that to be a false. That has to be something that is true. A counterfeit is called false. So we have to believe in if we have to be in a position that there is existence of an original ticket. As the de facto complaint has alleged that there is a forged ticket. So what is 464? 464 primarily states that making of the false document. So preparing of that false lottery ticket. That is their allegation. Now what is 465?
465. That is the penal section, 465.
464 is also penal, is a definition section whereby it states that a person is said to make a false document or a false electronic record. Firstly, he who dishonestly or fraudulently makes, signs, seals, or executes a document or part of a document, makes or transmits any electronic record or part or any electronic record, affixes any electronic signature or electronic record, makes any mark denoting the execution of a document or the authenticity of an electronic signature. Secondly, he who without lawful authority dishonestly or fraudulently by cancellation or otherwise alters a document or an electronic record in any material part thereof after it has been made, executed or affixed with electronic signature either by himself or by any other person, whether such person be living or dead at the time of such alteration. Thirdly, who dishonestly or fraudulently causes any person to sign, seal, execute or alter a document or an electronic record or to affix his electronic signature or any electronic record, knowing that such person by reason of unsoundness of mind or intoxication cannot, or that by reason of deception practiced upon him he does not know the contents of the document or the electronic record or the nature of the alteration. Now, if we come to the section 465, which is the penal section. Whoever commits 463 is forgery's definition, 465 is the punishment for forgery. The punishment laid out is which can be extended up to 2 years or with fine or with both. The third section that has been made out is 468 that has been leveled against this petitioner. Forgery for the purpose of cheating. Whoever commits forgery, including that the document or electronic record forged shall be used for the purpose of cheating, shall be punished with an imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine.
Okay.
So these are the three sections that has been leveled.
Yes.
What are the allegations that has been leveled is that I am counterfeiting lottery tickets and I have sold one of such lottery tickets to one particular person, namely Akshay Prakash Salunke. Secondly, I have bought 2 lottery tickets. After the draw was held, those tickets were declared to be the winning numbers. The numbers on those tickets were declared to be the winning numbers. I have bought those 2 tickets from people who had won the lottery through forceful and coercion act. That is the allegation the prosecution has brought against me. The FIR, my lord, kindly sees the date of FIR. The date of FIR is on the 9th of October 2023.
Where is the FIR? Page?
My lord, I think the state should have the FIR. Anyway, I have
Page
a copy
18.
of the FIR, my lord.
Page 18. No, that is notice.
I have a copy of the FIR. Oh, my lord's kind bill.
No, coming to that,
Yes.
the petition itself is defective. Therefore, seeking question of FR is not annexed.
Why is it not annexed? You're praying for quashing of the FIR.
Quashing of the FIR, the state should be having the FIR along with the case diary. Anyways, I have given one FIR, a copy of the FIR for my lord's kind perusal. Anyways, the state has it. They are prosecuting me.
No, even they have. And as far as the petition is concerned, they have to. It has to be effective.
Now, my lord, I'll just bring my lord's attention to the date of FIR. The formal FIR under section 154 CRPC, the date is
No, they are
9th
not
of.
praying for quashing. They are praying for quashing of the proceeding without praying for quashing. Anyway, yes.
The date of the FIR is 9th of October 2023. We are standing today in August 2025. So it's been close to 2 years that they are
FIR
investigating
is
into this FIR.
9/10/23. Yes.
Right. Almost 1 year, 10 months, madam. Now, in course of investigation that they have made certain allegation against me and they are prosecuting me, till date, the 2 holders of the lottery tickets, whom they are claiming, from whom I have coerced and forcefully took away the lottery tickets, they are not on board. They have not come and made any allegation against me, either in the home state or either in the state of Nagaland.
Who are the other two? This British Thakkar and
I
Mukesh
am
Thakkar?
not aware. I have not known them. I have no transactions with them. I have never seen them. To my utter surprise, I live in West Bengal in a district called Bankura, whereas accused number 2 and 3, Pritesh Thakkar and Mukesh Thakkar, are from Kolkata. The distance between Bankura and Kolkata is more than 400 kilometers. Now, my lord, kindly sees the FIR, the allegations. So, to make out section 464, the very first step that is to be taken, I am not going into the part of recording of the statement of the witnesses under 161. But the bare minimum that is to be done is to get hold of the lottery ticket that's original. Because they are putting forward an allegation that Akshay Prakash Salunke had won the lottery ticket. He submitted the lottery ticket before the camp office in Kolkata. The lottery ticket was found to be forged. Thereafter, they initiated proceedings against me. So, few things has to be taken into consideration. Number one, where is the original lottery ticket?
It says fake ticket printing racket.
Right. That is the allegation. Now, they have stated, my lord, I'll just draw my lord's kind attention is that.
The original will not be there because you are printing the fake ones.
My lord, I'll come to that. My lord, kindly comes to paragraph number 3.
Paragraph 3 of
the FIR, dated 20th July 2023.
Yes.
Paragraph number ticket, they have even sold one such fake and fabricated lottery ticket to one Akshay Prakash Salunke. Right? So, and that ticket has won a lottery. That is the reason he went to the camp office to claim his prize.
And eventually, Mr. Such and Such deposited the same for claiming the prize money.
Yes.
And when the said ticket was sent for revision, it became fake.
So this person went to the camp office. He has asked them that I won a lottery. Please give me the winning prize. Then they came up with a story that okay, the lottery ticket seems to be false.
Okay, we issue notice.
Ladyship, but
Yes.
still, here if you look at the prayer portion, page 13.
Sir, please let me come to it. I have very limited time. I'm gone so far. Let me come.
Okay. What else?
Now that is one.
That's all.
No.
You were
my
saying
lord.
that the ingredients
that
of
is
the
the first
sections-
part of the allegation.
Yes, okay.
Now my lord kindly sees another thing is that the original ticket has not been made out. Number 2, they are claiming a ticket to be forged. Who are they?
Not forged, but fake.
Fake. Who are claiming it to be fake? The de facto complainant. In course of investigation, that ticket must have been seized. I have given you the lower court record, the trial court record, certified copy. If there is a seizure under 102, that seizure has to be intimated to the jurisdictional magistrate. 1. Number 2, whether that is fake or not can be established through an expert opinion. That expert opinion has to be made out if an application is taken out by the investigating officer before the learned jurisdictional magistrate under section 91 of CRPC. That kindly allow me to send this to the forensic team to ensure that it is a fake lottery ticket. I can call it a fake. I am not an expert. I am just a de facto complainant. So 102 has not been ventured. 91 has not been ventured into in 1 year, 10 months.
So what is the stage of this investigation now?
They are still investigating after 1 year and 10 months. They are still investigating. The lottery ticket is the first thing that they should have seized. Because on basis of that lottery ticket, this FIR was drawn. It is not a case of assault, it is a case of forgery. So the document which they are claiming to be forged or fake, that is the first thing that has to be seized at the time of drawing of the FIR. You cannot sit on an investigation for several months without doing nothing. On the verge of, now I'll come to the part, the checkered backdrop as why they are sitting idle. That I will come to the later part. Why they are sitting idle.
No, at this stage we'll only issue notice. And another thing is,
My lord,
see,
I'll just complete. I'll just take 5 minutes. My lord.
your prayer is for quashing the GR such and such. But that GR 149 arose out of this FIR.
Right, my lord.
So, but you're not impugning this FIR.
My lord, the GR case is out of this FIR.
No, but this is the basis.
Yes, my lord. We have stated that.
The
My
FIR
lord.
is the basis.
We have stated that, my lord. My lord, in the post title itself, we have stated
And
that how the
investigation-
GR case has come out.
Investigation is still going on.
My lord, how the GR number has been put forward. Only when the FIR has been lodged. The FIR goes to the learned
You have
court.
in your petition throughout, you're referring to paragraph such and such of FIR, third paragraph of FIR, etc., etc. But the FIR is not assailed, FIR is not annexed.
My lord, we have stated in our prayer portion and Kohima North Police Station PS case number 51. Now it kindly comes to page 13, my lord.
GR such and such and Kohima North PS case 51. Yes, what else?
Now, this is the first part of the allegation. The second part of their allegation is that I have forcefully taken two tickets from two winning lottery tickets from 2 persons, and I have done that by an act of coercion and force. Now, my lord, till date there is no allegation, no FIR from any person wherein it could be gauged or found that I have coerced 2 persons and taken 2 tickets from them.
Where is that 2 persons?
They are not on record.
No, no.
There is no such person.
No, that statement in the FIR
My lord.
that you have coerced 2 persons to
Yes, my
hand
lord.
over.
I'm just showing. My lord, page 1, last paragraph. That would be first, second, third, 4th paragraph. The said Joydeep Datta submitted 2 prize claims that were forcefully purchased from the original winner by giving a small portion amount through ill-gotten money as stated above, and the details of the same are also provided below.
Okay. Then?
Now, where are these 2 persons? They have become fictitious
No,
persons.
not 2 persons. It says from the original winner.
Yes. Now, on page 2, my lord, you see there are 2 lottery tickets.
Yes, 2 lottery tickets.
Who are the original winners? I ask myself. Have they come on board? Have they made any complaint? Have they made any allegation? Have they lodged any FIR? Nothing.
Okay, then? Next.
Yes, now, let us come to the part that why this FIR was initially lodged against me. What is the checkered backdrop? The twofold allegation they have made out against me does not stand as on date after 1 year, 10 months of the investigation. Why they are sitting idle with their investigation, why they are not doing anything, and why this case at the very instance was lodged against me. My lord knows better than me is that if a lottery is won, 31.2% subject to my lord's correction has to be given as tax. By whom? By the by the person who are actually holding the lottery, who are actually taking care of the draw of the lotteries. In this case, the state of Nagaland. They have not given the government this 31.2% of tax. That amounts to 2 crores of lottery tickets would amount to 62,40,000 of tax. To evade this tax, to ensure this tax is not paid, they are holding my prize money, for which I have also filed 2 writ applications before my lord, item number 2 and 3. And they are also holding the tax of the government. This is the reason that they initiated this FIR. Otherwise, in this 1 year, 10 months, they would at least be in a position to bring forward those 2% who are the original owners. Moreover, they have stated, my lord, kindly comes to page 2 of this FIR.
You are saying that you are the rightful winner.
Yes, my lord. If I am not the rightful winner, then the rightful winners will be on board. Where are they? They have come up with allegations of money laundering act against me. In page 2, the first paragraph, after this names of the accused person and the details of the lottery tickets. In the FIR itself, page 2. If money laundering act, why didn't they initiate money laundering act against me? What prevented them? If I am a person who is purchasing lottery tickets from unknown person through force, through coercion, after them winning the lotteries, then obviously I will be implicated in money laundering act. They did not. Because as soon as money laundering act comes into play, the investigation cannot be done by the local police station. It has to be done from the part of the enforcement directorate. In this case also, the FIR was not made to the officer in charge or the person concerned, the director of the enforcement directorate. Actually, this FIR should have been made to the director of the enforcement directorate. They themselves are roaming here and there, trying to make the most out of this FIR by punching here and there, doing all sort of harakiri as how they can stop me from getting my winning ticket, the lottery prize money.
Okay, we'll see. We have to examine the case there. This is an application.
My lord, may I
Yes.
please, my lord?
Yes.
As on date, let further investigation be stopped. Let it be stayed. Let the case
No,
diary.
you yourself are saying for the past 1 year, 10 months, nothing is happening.
Yes, my lord.
Yes.
Why I am saying so is that
So we'll
as
see-
we have
we'll see
opened
the
our
next
defense,
day.
my lord. We have opened our defense. Let it be stayed for the time being. Let my lord peruse the case diary as till date what has happened. Let my because what they'll be doing now is they'll be filling up the loopholes. Let it be stayed. The further operations of investigation, let it be stayed. Let my lord kindly goes through the entire case diary in detail. Thereafter, if my lord thinks, my lord can again direct them to continue with the investigation. But as on date, let there be a stay.
Ladyship,
Yes.
the
And my lord,
petition-
if there is a
Short date, we'll give a short date.
the ladyship, the petition itself is very defective. Without IFR copy, how can it?
My lord, I will file a supplementary affidavit. Technicalities
How
do
can
not
it
come
even
in the
take
way
it?
of administration of justice. They are sitting idle for 1 year, 10 months.
You correct it.
I will file, my lord gives me a liberty to file
And
a
besides,
supplementary.
now investigation is going on, and the ratio laid down by the Supreme Court in Nihakari case, this randomly stay should not be granted. So as far as, even if notice is to be issued, I have a strong objection as far as issue of interim is concerned.
No, for
In
the
fact,
interim,
even
for
question
the-
is itself is are under for 528. High Court has very limited role to play. in
No,
this
my
kind of
lord.
nature.
No, my lord. I beg to differ on this point.
You will, but now I'm submitting. That is the law laid down by the Supreme Court. So as far as interim is concerned, I have a strong objection.
We'll consider on the next date.
Yes.
Yes, this is an application
My
under
lord,
section. Yes.
just for your, my
Yes,
lord's
yes,
kind
yes.
perusal, they are aware of this judgment. Probably the prosecution is aware of this. That is the reason they are staying away from it. I have marked the relevant portion. The holder of a ticket, if no other person claims it, is entitled to get the prize money.
No, but we are not on this now. We are on the.
No, I'm just saying this is the checkered backdrop and they are aware
We are
of
on
it.
the criminal proceeding.
They are aware
now.
of it, my lord.
This has got nothing to do with it. This is an application under section 482 of the CRPC / 528 of the BNSS, praying for quashing of the proceeding arising out of GR case number 149/2023
And Kohima.
in Kohima North PS case number 51/23 dated 23/8/2024 under sections 464/465/468/34 of the IPC. Stop. I have heard learned counsel for the petitioner. Shri, your name? Such and such, your name?
My lord, Mohammed Shamimuddin, MD. I'll give you a
Yes,
slip.
give it
I'll give you a
later.
slip.
Yes, such and such, and also learned PP for the state of Nagaland, Mr. Kiangami.
My lord, perhaps the date of the FIR is 9th of October 2023. There is also a mistake in my application. I have stated that as 20, but I seek liberty to file a
FIR
supplementary
date is
affidavit correcting all the date.
9/10/23. Yes. Where did you make the mistake? Which para?
My lord, in the prayer question wherein I have mentioned the FIR number and the GR case number, I stated that the FIR is dated 23rd of August 2024, page 13, my lord. Page 13, first paragraph. It should have been 9th of October 2023 instead of 23/8/24.
This should have been 9/10. 9/10. Stop. It is the case of the petitioner that the complainant, one Zotisa Dauhu, you just see from the petition, had lodged a complaint with the Kohima North PS case, being case number, North PS case number 51/2023. Stop. In the said complaint dated 20th July 2023, it was alleged that the petitioner, along with his associates, are engaged in the sale of fake lottery tickets under the name and logo of the Nagaland State Lotteries. So, it was further alleged that the petitioner has acquired the prize-winning tickets from the original winners by coercive means and has submitted the same at the Kolkata CAM office for claiming the prize. Stop. It was also alleged in the complaint that the petitioner has sold a ticket to one Mr. Akshay Prakash Salunke, and the same was found to be fake and fabricated. Fake, fabricated / forged. Stop. Accordingly, the FIR dated 9/10/2023 was lodged at the Kohima North PS case, and investigation is underway. Stop. The petitioner has, the case of the petitioner is that the ingredients of the penal sections charged against him are not present in the present case, inasmuch as the IO has not prayed before the magistrate concerned to send the said ticket for forensic examination. Stop. it is also stated that the allegation that the petitioner had forcefully taken the 2 winning lottery tickets is also false, as the alleged 2 original lottery ticket winners have not lodged any complaint, nor did they appear before the investigating agency. Stop. Para. Issue notice returnable within 2 weeks. Returnable within 2 weeks. Learned PP Mr. K. Angami has accepted notice on behalf of the state respondents.
1 to 3, Ladyship.
1 to 3, and accordingly, no formal notice is called for. The petitioner shall supply extra copies of the petition to the learned public prosecutor during the course of the day. The learned public prosecutor shall produce the scanned copy of the updated case diary on the next date.
My lord, and I seek for liberty for filing of the supplementary.
Yes, just wait. On the next returnable date, the interim prayer shall be considered. Stop. The petitioner has also prayed for liberty to file an IA, bringing on record the impugned FIR dated 9/10/2023, and also prays for leave to make a correction regarding the date in the prayer portion of the petition. So, the prayer is allowed. The petitioner shall file the necessary IA within a period of?
Within a
1
period
week.
of 10 days.
Within a period of 10 days. Stop. Yes.
And we'll serve a copy to sir.
Yes, serve today.
We'll
Today
copy,
itself.
serve a copy to the state.
Do you want the fixed date? After 2 weeks? Since you're coming from outside. 25th?
25th, yes, madam.
25th. 25th August.
For motion, item number 2.
My lord, 2 and 3 are both same. I'm for the petitioner in respect of both the writ applications. Those are in respect of the 2 winning lottery tickets, the prize of money of which I'm not being given by the state of Nagaland.
To disperse the prize money. in
Yes,
favor
madam.
of the petitioner.
There were 2 tickets for which there are 2 separate cause of actions. As the tickets were held, the lottery draw were held separately, and we are paying for disbursement of the winning prize money in respect of both the winning lottery. They have not claimed that these lottery tickets were fake. They are only saying that I have coerced someone, XYZ, and I have collected the lottery tickets from them, but that XYZ person, that fictitious person, is to still come on board.
What is this order of the High Court of Calcutta?
My lord, we had prayed before the Honorable High Court at Calcutta with making the similar prayer, but since it lacked territorial jurisdiction,
Okay.
Honorable Justice Amrita Sinha was pleased to direct the petitioner that if advised, the petitioner can go to the Honorable Jurisdictional Court,
Approach before the
as all the case record and all documents are lying in the state of Nagaland. And the state of West Bengal cannot invoke any writ jurisdiction for any cause of action that arises in the state of Nagaland. So we were given a liberty to file before this honorable
Yes,
court.
yes. This application, yes, this is an application under Article 226 of the Constitution of India, praying for
Lady Shi, if I may interrupt.
yes.
Actually, these applications are premature. Disputed questions of facts are there, as we can see from the first item in the criminal petition. So unless that is sorted out, I don't know whether it will serve any purpose to them, because
Ultimately, yes, we'll have to look into that because now they are saying that you are not the prize winner.
That is up to them.
Ah.
That is up to
They are
them.
saying you are not the prize
That is up to them. May I please? My lord, let them disburse the government's tax. Let my amount be on hold.
No, let them file their affidavit. Let them
Yes,
file
yes,
their
yes, my
affidavit,
lord.
we'll see.
Yes, my lord.
Because as of now, only this record we have to see. So when you see this record, they are claiming, that's all. Then while filing the affidavit, you can bring your grounds. Yes. Bring for a writ of mandamus, calling upon the respondent authorities to disperse the prize money of lottery. What is that? Where is that? Prize money.
Of 1 CR.
No, I'm talking about the name.
Joydeep
The prize money won by him in a lottery ticket issued by the Dear DEAR, Dear Government Lotteries, under the name Nagaland State Lottery, Dear Ostrich Evening Saturday Weekly Lottery, held on 25/3/2023. Stop. And the petitioner has claimed has made the said prayer on the ground that he is he has a rightful claim to the prize money, but the same has been denied by the state respondents. Stop. Issue notice returnable within 4 weeks. Learned Government Advocate Mr. K. Angami accepts notice on behalf of the respondents number 1, 2, and 3.
6.
Oh, no.
All
One,
respondents.
yes, all the respondents 1 to 6. And hence no formal notice is called for. Stop. The learned counsel for the petitioner shall supply extra copies of the writ petition to the learned government advocate during the course of the day. Stop. Days of the 4 weeks. Yes. What is item 3?
3 is same except for the draw of the lottery ticket will be on 18th of March 2023. It is the same lottery ticket, Nagaland State Lottery, here, Ostrich Evening, Saturday evening.
Okay, same order, but the lottery ticket will be different. This one is.
This was held on 18th of March 2023, page 4.
Wait. This one is Nagaland State Lottery, Dear Konai Morning Saturday Weekly Lottery, drawn on 18/3/2023. Same order after 4 weeks. Yes.
For motion, item numbers 4 and 5.
Please, my lord. Here the present application has been filed by the petitioner 38, 40, 42, 43 and 44 for deleting their names in the main petition. On the ground that the petition, I have stated.
Main petition is 172.
Yes, my lord.
Acha, why?
My application page 13. Here, my lord, petitioner 38, 42, 43 and 44, I was informed by the petitioner that now they are on fixed pay pieces only. So in the main writ petition, I am claiming for service regularization as per the 1 OM 17 2015. And then,
Okay, in 172.
yes. And then for fixed employees, they are not covered by the set of fixed memorandum.
Yes, they are not.
So for that, for safer side, it has been filed for deletion of their name.
You
And
can-
then petitioner number 40. Here, the petitioner has filed one writ petition, that is WBC 276 of 2023, which is pending disposal. So to avoid multiplicity of proceedings, again I filed this for deletion of
Oh,
petition
you are
number
there,
40.
40 is there in 172 also. No, all
And
of them.
276, yes, my lord. My paragraph 2 at page 13.
Wait. Just make this clear. Petitioner 38, 40, 42, 43 and 44, they want their names to be deleted from the list of petitioner in WPC 172.
My lord.
And then what about, and you were saying something about 40?
Petition number 40, he has filed another writ petition.
Which one is that?
WBC 276 of 2023.
276 of 2023.
Yes, which is pending disposal. So I've stated earlier, as to avoid multiplicity of proceedings.
So that means he was petitioner in 172 as well as 276.
My lord, yes.
Okay. Yes, no objections. By filing this IA under Order 1, Rule 10, Clause 2 of the CPC, the petitioner, the applicant has prayed for striking out the name of petitioner number 38, 40, 42, 43 and 44 from the list of petitioners in WPC 172 of 2024. Stop. Learned counsel for the applicants, Mr. S. Wally, submits that WPC 174 or 172?
172.
You have written 174 in your para 1. That WPC 172 of 2024 is pending disposal before this court, in which the petitioners are seeking regularization of their service as per OM dated 17/3/2015. Stop. However, it has come to light that the petitioners are fixed pay employees and therefore cannot avail the service regularization as per OM dated 17/3/2015. Stop. Accordingly, the applicants have prayed for deleting of their names from the list of petitioners in WPC 172 of 2024. Stop. As far as petitioner number 40 is concerned, it is stated that the petitioner 40 Sri Chingkong Kongyak, CHINGKON, Chingkong Kongyak, has filed another writ petition being WPC 276 of 2023, which is still pending before this court. Stop. Learned counsel for the respondent number.
Lordship, I am for the petitioner, counsel for the petitioner in WPC 155 of 2022.
The petition counsel for the petitioners in such and such is present. Stop. And learned government advocate is present and have no objections. Stop. Accordingly, the petition, the IA is allowed, and it is directed that the names of petitioner number 38, 40, 42, 43 and 44 may be deleted from the list of petitioners in WPC 172 of 2024. Application stands disposed.
My lord, in the main rate, I may be allowed to file an amendment.
Yes, in WPC 172, you say, in view of the order passed in IA 145 of 2025, the petitioner is allowed to file an amended post title.
Amended petition.
Amended petition. Yes.
My lord, item number 5, that is WPC 155 of 2022.
No,
So
how much time will you take to file?
2 days.
Least after 2 weeks, just say 2 weeks.
And then my lord, WPC 172 of 2024 and WPC 155 of 2022. That is item number 5. Item number 5 may be separated from item number 4. Why? Because on the earlier occasion, I filed one IA. On the basis of that, this particular writ petition was listed together. So it may be separated.
Separated?
Yes.
172 and
172 of-
155.
Yes, my lord. Item number 4 and 5.
Learned counsel for the petition, now you pass order in 155. Learned counsel for the petitioner, Mr. S. Walling submits that the WPC 155 of 2022 and 172 of 2024 are not analogous. They are not analogous matters. No? They are not analogous matters, and therefore they may be delinked. Stop. Upon the prayers allowed, this petition, writ petition, the writ petition 155 of 2022 and WP 172 of 2024 may be delinked and listed separately.
For motion from the supplementary cost list, item number 24.
May I please, Lordship?
Yes.
Lordship, this application is, we are praying for deletion of the village council from the party of respondent.
You serve notice.
Lordship, yes, but the main council is not present today.
Lordship, my senior is not present today, Inti Longjun.
Okay.
So,
Lordship, we will be filing our objection.
You file your objection?
Yes, Your Lordship.
What is this? What do you have done?
yes, Lordship, Lordship, may kindly turn to the cause title of the
Traditional
petition.
established statutory body and the village council are two different entities.
On that ground, Lordship. Lordship, in the cause title, in the main writ petition, you kindly refer to that beach then of 14, Lordship. The village council has been half-heartedly
Putu Mandan slash village
Yes.
council.
half-heartedly made a party.
No, but in most our villages it's the same.
No, Lordship, I agree. Theoretically,
Village council and government is the
theoretically they may be, but in practical terms,
No,
they perform
when
different
they function
functions.
in traditional, all this they function as Putu Mandan, and when they function for the administration, then they function as
Yes,
village
as
council.
a village council. That's what I'm saying, Lordship. Now the action.
The same persons.
Yes, the given information in
Okay,
the
anyway,
announcement.
since they want to file an objection.
Yes, Lord.
Yes. This application has been filed praying for deletion of the Young Yimson Village Council as party respondent number 1 from the cause title in the connected WPC 90 of 2025. Stop. Learned counsel for the petitioner, Mr. Apok Pomoner. Stop. Learned counsel, Ms. Such and such,
And Solo.
appears on behalf of the petitioner slash opposite party.
1 to 38.
What about government petitioner slash opposite party number? Okay, wait, okay.
1 to 38, Lord.
1 to 38.
Yes.
Comma. Government advocate, Ms. Such and such for respondents number
3, 4, 5, 6.
39.
39 to
39 to
42.
42.
39 to 42.
42 and Mr. T.B. Jamir for opposite party number 43 and 44. Stop. You'll also file objection? Okay. Learned Counsel, Mr. T.B. Jamir has been for 4 weeks to file an objection in the main petition.
In the main petition, then IAP decided to proceed.
Okay. They'll file the affidavit. File this affidavit. Stop. Learned Counsel, Ms. Such and Such also makes a similar prayer to list the matter after 4 weeks to file the objection to the IA. List after 4 weeks.
So, main writ petition also better. Main writ petition to also discuss the four.
Yes, in the main petition also, WPC 90, lists the matter after 4 weeks in order to for the respondents to file their affidavit in opposition. Government also has not filed, no?
Not yet.
You have filed, or you are the petitioner in that? Yes, okay. After 4 weeks, main case also. Any interim order?
I don't know, Lordship. I've just joined.
For admission, item number 11.
Please, Your Ladyship.
Yes.
Your Ladyship, by this revision petition, I'm challenging the impugned judgment and order of Deputy Commissioner passed on 11/3/2025. However, Lordship,
Respondent, yes.
yes, while moving this revision petition, there was a delay of 10 days, and therefore I've filed a condonation in that regard also, an application for condonation of delay.
You are appearing for respondent?
Yes, I'm appearing for the sole respondent. We have received instruction to appear and have already filed a Nagaland.
Okay. Are you objecting to the condonation
No,
prayer?
we have no objection to that.
Okay, then we'll allow and we'll take up the main case.
Lordship.
This is IA, okay? IA 107. Learned Counsel for the petitioner, Mr. T.K.Z. Stop. Learned Counsel, MS such and such. Just give your name.
Yes. Lordship, though I have signed the Bagalat my name has not been reflected in the constitution list.
So who will appear? You will appear or?
Yes, I'll appear. I'm appearing.
It's okay, we'll give a direction to, but see, have you given your name to the registry? It has to be registered in the CIS, then only it will appear.
My name is already registered, but I don't know what happened. In this case, my name is not reflected.
Anyway, you give your name to the steno also, okay? Learned Counsel, MS such and such, has appeared and made a submission that she has received instructions to appear on behalf of the sole respondent and has already filed her Vakalatnama. Stop. The present IA under Section 5 of the Limitation Act 1963 has been filed, praying for condonation of 10 days delay in filing the connected civil revision. Connected civil revision 3 of 2025. Stop. The counsel for the applicant / petitioner submits that. Where is your reason? Which para?
Lord, I've set out the reasons in para 4 of the application.
Para 4 stated that the Deputy Commissioner Kohima had heard the civil appeal 2 of 2023 on 24/4/2024, and only after a lapse of 1 year. Wait. 24/4/24 is the date of the judgment.
That is the date of the hearing of the appeal.
Okay. Only after a lapse of 1 year, the councils were contacted by the Deputy Commissioner's office on 18/3/2025 to obtain a copy of the judgment and order in the said appeal. On the said day, a certified true copy of the same was obtained. It is stated that the impugned judgment and order is indicated as 11/3/2025. Thereafter, the applicant had communicated to his counsels that they were considering the possibility of settling the dispute amicably outside the court. As no information was forthcoming for a considerable period of time regarding the amicable settlement, it was only on 22/5/2025 that the applicants communicated to the council that the efforts towards the settlement did not materialize and that they have decided to pursue the legal remedies available to them. Upon receiving such communication, the council previously engaged by the applicant had informed the applicant that he had undertaken an official assignment entrusted to him by the government and that he could not take up the matter. And thereafter, the applicant had approached the present council on 23/5/2025. During the relevant period of time, the present council was preoccupied with attending to ailing family members and was out of station for the medical duties, due to which some time was taken to prepare the present revision petition. Thereafter, the present council made an attempt to file the petition on 16/6/2025, however, on detecting certain discrepancies, further instructions were sought from the applicants, and after making the necessary corrections, another 10 days was spent in the preparation. It is stated that the limitation period of 90 days has expired on 9/6/2025 if counted from the date of judgment and order, however, the certified true copy of the judgment and order was made available only on 18/3/2025, thus the limitation period from the date of obtaining the certified true copy would expire on 16/6/2025. Hence, there is a total delay of 10 days beyond the prescribed limitation period. It is submitted that the delay has not been deliberate or intentional, and the delay was caused beyond the control of the applicants. Learned counsel for the sole respondent submits that she has no objections if the court condones the delay, and has instead submitted that the main revision petition may be heard on merits. Accordingly, this court is of the view that sufficient cause has been shown by the petitioner for the delay of 10 days. Accordingly, the delay of 10 days is condoned and the application is allowed. Application stands disposed. Then come to civil revision treatment case. In the main case, will you be filing any objections? Civil revision 3.
We are yet to receive the copy of the
Madam, I'm yet to
petition.
serve a
Oh,
copy.
okay, please. Okay. The present petition has been filed under Article 227 of the Constitution of India, read with Rule 32 of the Rules for Administration of Justice and Police in Nagaland 1937, impugning the judgment and order dated 11/3/2025 passed by the Deputy Commissioner Kohima in Civil Appeal 2 of 2023. Issue notice returnable within 4 weeks. Stop. As the sole respondent has already entered appearance by filing Vaklatnama, no formal notice is called for. Stop. However, the learned counsel for the petitioner shall serve extra copy of the petition on the learned counsel for the respondent. Stop. This is the matter after 4 weeks. The respondent is at liberty to file objections if so advised. And next para, call for the records of, what was the case number? Call for the records of Civil Appeal 2. Call for the records of
Civil Appeal 2 of
2023 from the Court of the Deputy Commissioner Kohima, Nagaland.
My Lord, I'm also praying for interim for staying of the impugned judgment in order.
You have made a prayer.
My Lord, in that regard, may I give a brief submission?
Yes, yes.
Yes, the case is prima facie in my favor, in as much as the Deputy Commissioner, instead of adjudicating on the grounds, the substantial grounds raised in the appeal, dismiss the appeal solely on the ground of jurisdiction, which was already decided in the earlier revision petition. I was here before this honorable court on an earlier revision petition also. So prima facie, it's in my favor. When it comes to balance of convenience, Lordship, I'm still in the possession, and I'm the first to purchase the suit land. And purportedly, after some time, the same clan members have sold the suit land to the respondent. And therefore, balance of convenience is also in my favor. And if third-party interest is to be created, then irreparable loss is going to be caused to me. And therefore, I'm praying that interim may be issued, may be given in my favor.
Lordship, since we are yet to receive the copy of the petition, the prayer for interim may be considered only on the next day.
There is no provision to the prayer for interim stay of the impugned order dated 11/3/2025 shall be considered on the next returnable date.
Highly obliged, Lord.
For orders, item number 12.
My lady, I beg for indulgence in item 24. Your Lordship, there is an interim in the main writ petition.
That's why I was asking you.
Yes, Your Lordship.
Item 24, no? The interim order passed earlier shall continue until the next date.
Much obliged.
Your Ladyship, in
Yes.
compliance of this honorable court's order, I've taken steps upon the respondents one and two by registered post on 22nd of July 2025.
This is civil revision 5, no? service report awaited. Service notice issued on 24/7. Office note dated 24/7/2025 indicates that the notice by registered post was sent on 23/7/2025. However, the return service report is still awaited. So, accordingly, list the matter after 3 weeks awaiting return service report on respondent number 1 and 2. Unit Counsel for the petitioner, Mr. Marjam, is present.
Obliged.
For orders, item number 13.
May it please, my Lordship, I have filed the affidavit upon taking steps taken upon the respondents 2 and 5 on 4th of August before this honorable court. Steps have already been completed.
Affidavit of dusty service upon petition. Yes, you are appealing for?
Private respondents 2 to 5.
2 to 5. Is this a joint petition?
It's not a joint petition, but there has been a compromise between the parties.
Yes.
Scanned copy of the CD is yet to be consulted. It will be called.
Okay, Learned Counsel for the petitioner, Mr. Setiano, is present. Stop. The affidavit of dusty service notice upon respondent number 2, 3, 4 and 5 has been filed, and today when the matter is called, Learned Counsel Mr. Such and such appears on behalf of all the respondents, no? All the respondents.
All the private
respondents. No? Learned Government Advocate Ms. Ismeri is present and has submitted that the scanned copy of the case diary is yet to be received by her. Stop. Accordingly, we can list it after 1 week.
Call for the CD.
We will call. Yes, 1 week will do, or 2 weeks.
Yes, 1 week will do.
List after 1 week, and the learned PP is directed to obtain the scanned copy of case diary.
Much obliged.
Lordship, may I just interrupt your Lordship?
Yes, yes.
Lordship, forgot to mention one item. Item 23 in the 22.
In the hearing.
Hearing, Lordship.
Item
22. Lordship, I've received an instruction to appear on behalf of the respondent number 11, that is the former respondent, the village council Kansa. And I'm yet to file the power in the affidavit. Lordship, may I pray that I need to grant 2 weeks' time for it?
Yes. Learned Counsel, Mr. Apo Pongoner, has entered appearance for the respondent number 11 and prays for 2 weeks' time to file his Vaklat Nama as well as affidavit in opposition. Stop. Learned Counsel for the petitioner, Mr. M.T. Longchar, is present and there's no objection. List after 2 weeks.
Obliged,
Yes.
much.
For hearing, item number 19.
How many hearing after this? One more, no? Yes. Is this a short matter or complicated long matter?
It's a short matter.
Because if I have to write a long judgment, I don't want to take it up.
Your Honor,
What is it about?
By this petition, the petitioner is seeking for appropriate compensation.
Compensation?
For the damages
For?
caused to her building on account of the two-lane road construction. Now, Your Honor, Your Lordship, sometime during the year 2018 and 19, there was a two land extension in the stretch of Marangkung, Tamlo, and Mon Road. Now, the issue here pertains to the stretch at Tamlo, under Longling District. Now, for the construction of this road, Your Honor.
What about Union? Union is also party.
Yes, Your Lordship.
Yes, my lord. NZ Ule was appearing for Union of India.
They have filed the affidavit.
Lordship, they have refused. They have said that they will not be filing. They have made a submission.
They will not be filing.
Yeah, they have already made a submission before this honorable court.
My lord, he was around.
May I proceed?
Yes.
Lordship, sometime in the year 2018, for the widening of two-lane road in that stretch.
No, they will not be filing means they are not disputing your claim or they
Lordship,
are disputing or what?
They only want to make a verbal submission. That is what they have also contended before this honorable court.
No, because normally it depends on whether the road is state highway or national highway.
On the last occasion, Lordship, I have also made a submission that they are also the financing authority. So they ought to actually file a reply in a small affidavit or whichever way. But even on the last occasion, yes.
Yes, Mr. LT. Is it a national highway or state highway? This one?
This is NH, National Highway.
National highway.
Yes, ma'am.
Then in that case, isn't the union government a
It's
necessary
must.
party?
It's necessary, ma'am.
Yes.
Necessary.
Because they are the main financing authority.
Yes, yes, ma'am.
And if you're praying for compensation, then they will have to pay.
That is the submission that I made on the last occasion as well. But this honorable court was also fine with the submission made by the council.
Without their presence, how can the court adjudicate? You're also saying that, isn't it, Mr. Sanktam, in your affidavit? Are you saying that they are the financing authority?
Yes, my lord. Yes, ma'am. We are only a supervisory agent.
Mr. Muli, you are appearing in this matter. So
Yes,
why are you not filing affidavit? This is a national highway.
Yes. This is national highway, but this allegation is mainly for NHIDCL and state government. So that, on addition to that,
So NHIDCL is also a party.
Yes.
Oh, you're there.
So that here,
Okay.
I'm only a performer respondent.
No, Lordship, he is not a performer respondent. I have not reflected anywhere in my petition.
Yes, fund is released by the ministry. NHIDCL is the implementing agency.
Yes, NHIDCL and state government is implementing agency.
Yes.
So that the very responsibility is up to them. On the top of that,
How can the ministry just absorb their liabilities like that?
My lord, he is the employer. We are only a supervisory agent. Unless and until the sanction is granted by them, we cannot start with the construction of national highway.
yes,
how can you
my lord,
just say that it is
DPR is submitted by state respondents. And according to that, with the Union of India have
Agreed.
sanctioned
That is
mark
right.
accordingly.
But ultimately, the funds have to be sanctioned by you.
Yes.
Yes.
So that based on
And
the
if-
DPR submitted by the
And if
state
any
respondent.
compensation has to be paid, that also has to be sanctioned by you.
So that's better. DPR. DPC, we have to sanction that amount.
You have sanctioned?
Yes, we have given them to implement. But
No, you have sanctioned the compensation amount also.
no, yes, that one is also we have the sanction. We have given this particular loan district. This one is we have given additional rupees 19 crores 85,000 85 lakh 93,671. That one is as per the contempt petition filed by the other petitioners.
Other parties.
Accordingly, before this Your Lordship court, that one is also adjudicated. So, not particular, we have issued a check to the Deputy Commissioner Longbei in the month of this 1st December 2024. So, whether the state government is implementing or not, that one, how they are executing, that one, I'm not aware of that. So that I'm just a performer respondent. I'm stating like that.
You are not a performer respondent. You have to state exactly how much you have released and for what purpose. All those you have to state. Where is it? Respondent number 2. You have not filed anything.
Yes, I have not filed anything. Your Worship.
This will not do. You file an affidavit. Even if it's a 2-page affidavit, that will do. Whatever you are stating verbally, that has to come in written. You file your affidavit, okay?
My Lord, but the petition
how much
also
time? How
will
much
be
time?
aware of that, which
2 weeks. They may be aware, the state response all may be aware, but you have to state in written in your affidavit that we have released this much amount for this, like that, everything. Now you're telling the court, isn't it?
Yes,
That you
yes.
have released this much amount. So that has to come in the way of affidavit, by way of affidavit. Otherwise, how will the court adjudicate when nothing is there in written? That in the order, everything has to be mentioned by the court. And we cannot mention it unless, we cannot mention it just on the basis of your verbal submission. You put it in writing. Okay. The present writ application, writ petition under Article 226 has been filed by the petitioners. Petitioner or petitioners?
Petitioner.
For non-consideration of the petitioner's case for compensation as an affected landowner under the SARDP-NE, capital letters, okay, SARDP-NE phase A, comma, during the widening of 2 lane on Changdongya-Longleng Road,
Your Lordship, here specifically it's to do with Mon Tamlo Marangkung Road.
not this Changdongya
Yeah,
Longleng,
not this stretch.
widening of 2 lane on Mon-Tamlo-Marangkung Road in the state of Nagaland. Stop. The petitioner is one of the landowners who is aggrieved for non-compensation for the properties damaged. Stop. The state respondents are represented by the Learned Additional AG, Mr. L.T. Sankam, and the respondent number 7, NHIDCL, is represented by Mr. Moa Jamir. And the Union of India is represented by Mr. Z.N. Modi, who submits that the present case is related to a central project and the union has already released the funds to the state government and the NHIDCL, who are the implementing agencies. Stop. However, no affidavit has been filed by the respondent number 2, Union of India, stating the same in affidavit. Stop. Accordingly, the respondent number 2 is granted
4 weeks.
4 weeks time to file an affidavit regarding the status of the release of funds for the said project. For the said project, that is, i.e., SARDP-NE phase 1, phase A. Phase A, comma, widening of Mon-Tamlu-Marangkung Road. List of the 4 weeks.
Your Lordship, this order may be kindly.
A copy of the order may be furnished to the learned CGC.
Must
5 minutes, okay?
For hearing, item number 23.
Lordship, before my learned friend began, the matter should have been listed in the admission column, I believe. It's listed in the hearing list. But
Actually,
anyway, Lordship,
in this case, the service is yet to be
Not
completed.
complete.
Yes.
and it has not been
Then why
admitted
did
as
it
yet.
come for hearing?
Lordship, hearing should have been for the condonation only.
It ought to have
There
been
is a
listed.
prayer for continuation also.
Yes. So it ought to have been listed in the admission list.
Yes. In fact, in principal seat, without condonation, the main case is not even registered.
Yes.
They don't even register it.
Yes.
Acha, last order, it said for hearing, that was,
Yes.
we
That
actually
is
meant
specific.
for the IA.
Yes.
Yes. 5 and 6. Who are 5 and 6? Driver?
Driver and owner. Lordship, the driver and the owner, they contested.
They contested.
Yes, in the
yes.
tribunal. So, Lordship, if the condemnation application can be decided, first,
Series of notice issued upon respondent 5 has written and served with remark, please mention house number and contact number. Return service report in respect of R6 still awaited.
and the practical difficulty in getting the notice served, my lady, the service, I mean the address they have provided in the claim petition as well as in also the judgment copy, it is the same address in which I have taken the service. So,
Before the trial court,
They
how
appeared.
did they appear? I mean, did you serve notice by Dusty or what happened? Or newspaper
Your
publication?
Honor, my lady, that I am not aware of because I was not the counsel. I
Okay.
have to. They appeared, Lordship. They appeared through counsel. Yes. Or else, my lady, let the service first be completed.
That's why I'm thinking.
This
if
honorable
they
court
appeared.
feels so.
So let's give one more chance then.
Okay. But Lordship, counter to that, if the condemnation is decided that will serve the purpose, it will serve the purpose.
Are you objecting seriously?
Lordship, I
Yes, filed his
objected. I
objection.
always take it seriously, Lordship. Lordship, the
Okay.
some loopholes are there which I would like to point out. Because my learned friend in his statement has said that in the condemnation application has stated that he has received on the 26th November.
How many days?
94 days.
94.
Yes. And the ground
Will allow.
and the ground that they have taken in the condemnation application is that due to the closure of the registry, no filing could be done. Lordship, the registry opened on the 6th of January in 2025. And it was filed only on the 5th March. In that case, my lady, if I may take to my IA, paragraph number 7 of the IA, internal page number 5. May I read?
Yes.
That the applicant has a divisional office in Jorhat, Assam. It has a branch office in Gauhati, Assam, as well as in Dimapur, Nagaland. Applicant's counsel based its motion on receipt of the said judgment forwarded the same to the applicant's regional office situated at Kolkata on 4/11/2024. The regional office on receipt of the judgment dated 25/10/2024 forwarded the same along with the file to its head office in Mumbai on 7/11/2024 for approval, advice in preferring the McAppeal. The applicant's regional office on receipt of the entire file forwarded the hard copies to its panel advocate at Dimapur, which was received on 26/11/2024 to prefer the McAppeal before the Honorable Gauhati High Court, Kohima bench against the impugned judgment and order dated 25/10/2024. Applicant's panel counsel, though received the hard copies of the case number so and so for filing an appeal, counsel was pre-engaged with other cases and could not proceed for filing the same. Honorable High Court was on Christmas and winter holidays with effect from 21/12/2024 to 15/1/2025. instant McAppeal was finally filed on 5/3/2025, but due to some defects in the petition, as pointed out by the registration section of this Honorable High Court, memo of appeal and connected interlocutory application were returned to the Council for necessary corrections and filing afresh. In the meantime, the statutory deposit has also expired. The Council did the necessary corrections and forwarded the same for signatures. In the meantime, the fresh statutory deposit check was received only on 7/4/2025. The period of limitation for filing an appeal being 90 days expired on 25/1/2025. Thus, there has been an unintentional delay of 94 days in filing the instant McAppeal.
Acha, what about 15/1/25 to 5/3? What happened in between?
There is no
Just see
explanation.
the High Court was on Christmas and winter holidays with effect from 21/12/24 to 15/1/25.
Yes.
The instant McAppeal was filed on, okay. Finally, it was filed on 5/3.
It was filed on 5/3.
But again,
but due to
because of
some
defects, you didn't-
defects, it was in the defective.
So what happened between 15/1 and 5/3?
15/1 and 5/3, my lady, the appeal was prepared. But as the lady is aware that the being the corporation, we have to send it for vetting. So it was sent for vetting. Earlier this MSc cases, it was dealt by Gauhati regional office. Then after that, internally, what they told that internally there was some change in the process. Then the MAC cases, it has been looked up by the Kolkata office.
No, what I mean is,
Yes.
the reasons you are saying vetting, sending for vetting and all that,
Yes.
that has not been stated here. So between 15/1/25 and 5/3, there's a big gap.
Yes.
More than 1 month.
Yes. Although it is not stated, but if I may take my lady to the annexures, I have annexed herein.
Lordship, I must point out that there has been some lapses. Lordship, as per the record, may I just place this? This is an order of November 2024, whereby the registry of this court was opened on the 6th of January 2025. So that is contrary to the statement made in the.
No, the registry, they have roster.
Yes.
So sometimes it may so happen that the person on roster may not be there in the
No,
office.
no,
These things do happen.
But that is contrary to the statement. The statement says on the 15th of January, the court opens.
Yes, the court function started from 15th of Jan.
Yes, the court, but the registry functioned earlier than that.
Might be.
That is what I wanted to show.
My
Lordship,
lady, as per my
Yes, you were showing some documents.
yes, as per my annexure 6, internal page number 28, annexure 6. It is the email intimation to the company when I have sent it for vetting. It was sent on 5th of February 2025.
Page 27.
no page
Page 20,
copy.
28.
Oh, 28.
Yes.
Then what is this annexure 7?
Annexure 7 is the consignment note when the company had sent it to me, the hard copies, after vetting. I have sent on 5/2 and they have returned it on 24/2. Then after that, there was some objections, compliance by the registration section of this code. So it is dated 5/3/2025.
Where is that? Where is the date?
It is on the
Okay,
right
okay,
hand
okay,
top
yes.
corner,
5/3/25.
page 29.
So when you filed it on 5/3/25, there were some
Complications, I mean, there were some objections noted by the registry, the registration section. And it was returned, and it was advised by the registration to correct the defects. And
Then what is page 31? Page 30 is the objection, then page 31.
uh,
When was it filed? When was this filed? Huh? When was this action filed?
earlier it was filed on 5/3.
Isn't it the same? Page 30 and 31, isn't it the same?
No, 30 is the intimation to the corporation about the objections and defects raised by the registration section.
Then page 32 is your email for the check for the statutory deposit.
Yes. In the meantime, the statutory deposit has also expired during this process. And
What is this page 33? Shipment.
page 33 is the shipment tracking report after the corrections when I have received it. It was the last page, lady. It was picked up from Gauhati at on 5th April 2025.
The petition.
Yes,
What?
the hard copies after
After correction.
corrections. Yes, it was picked up at Gauhati. Then from Gauhati, it did not come to Dimapur directly. It went to Jorhat. Then I have received it on Dimapur on 7th.
Okay. Your objection is regarding this holiday.
Lordship, there has not been consistent explanation, Lordship. Lordship will kindly take note of the statement of the applicant. Appears on 4, according to the petition, on page para 7, appears that the council based at Bokokcho had sent it on the 4th of November 2024. But the annexure that has been annexed along on that, this annexure 2, which is part of para 7, Lordship, annexure 2. Lordship, this, since my petition is not dated.
Yes, to the manager SBI.
Yes, this is a letter from the council at Mokokchung. This is dated 6/11, 2024.
7/11.
And Lordship, on top it is dated 6/11,
But
but I'm
signature
coming to
is,
that. Signature is
7/11.
dated on 7/11. How could it be, Lordship? The contradiction is there, Lordship.
No. While signing, some people are like that. They won't look at the top and they'll just put any
And my
any
lady,
date.
if I may.
No, Lordship,
No,
according to the
you mean 4th and 7th.
Yes,
Between 4th and
that's
7th.
the discrepancy is that one. According to
we
them,
are-
they have received it on the.
And we are at the age of digital era, so it might
But then
also.
the date cannot be even in the digital area.
No. That I'm not talking, sir. That might
If
be.
we're
There
in the
might be
digital
possibility
area,
that on
why
4/11
was the need for you to send the hard copies?
then
If that is the argument, Lordship.
might be on 4/11 he might have sent through an email to the company, and for filing the appeal we cannot file it with digital
Forwarded
copies.
the same to the regional office on 4/11,
We can do it on PDF.
but this was signed on 7/11. That's what you want to say.
So the argument of the digital area, Lordship, that is, the same thing could have been done in his case. For 2 months, Lordship, from November 26, 2024, the whole of January and February, there is no explanation. So at least what I'm saying is that there must be some consistency in the explanation. There is no hard and fast rule on that, Lordship. Your Lordship knows better. But there must be some consistency in the explanation. And without that consistent explanation, it will be, Lordship, because by the time this appeal has been filed, the judgment degree holder has gained some right, Lordship. And that has to be looked into that, from that angle.
You have come on what ground? Quantum.
Quantum as well as some other grounds also.
All the grounds are just mechanical
question
and
of
standard
merit
pleadings. And if we go to the merit, Lordship, in fact, no permission under 170 has been granted. And they have not taken a single ground on that, Lordship. On the rejection of your prayer under 170B.
Permission.
Yes. It has been rejected, but they have not taken, not a whisper on that. No ground has been taken.
My lady
on
is
that.
aware of the fact that, as per Shiladitta,
No,
if
Shiladitta
the,
has already
if the
been
insurance
overruled.
company is made a party respondent by the claimant himself or by the tribunal by default, then permission under 170
Shiladitta is not a judgment, Lordship,
is not required.
authority. Because it has, they have, in Shiladitta, they have referred it to a larger bench.
Larger benches.
Yes. And that has not been decided. Because we cannot hold Shiladitta as an authority in this. The only authority on 170B is the case of Josephine James.
Let's allow this continuation. The present application under Section 5 of the Indian Limitation Act 1963 has been filed by the appellant / applicant for continuation of delay of 94 days in filing the connected MSc Appeal 8 of 2025. Stop. The learned counsel for the applicant, Mr. V. Debnath, has submitted on the basis of his application that the applicant has a divisional office in Jorhat as well as in Gauhati, Assam, and in Dimapur, Nagaland. Stop. The applicant's counsel, based at Mukchung, had forwarded the judgment and award, had forwarded a copy of the judgment and award dated 25/10/2024 to the applicant's regional office situated at Kolkata. On which date should you use? The date in your application or the date in the letter? In the letter is 7/11.
My lady, in that case, because on 7/11 the corporation had sent it to Mumbai for approval. Annexure 3.
On receipt of the judgment and order dated 25/10/2024, forwarded the same along with the file to its head office in Mumbai on 7/11/2024 for approval / advice to file the MSc appeal. Stop. The applicant's regional office, on receipt of the file, forwarded the hard copies to the panel advocate at Dimapur, which was received on 26/11/2024, to prefer the MSc appeal before the Gauhati High Court Kohima bench against the impugned judgment and order dated 25/10/2024. Stop. The panel counsel of the applicant, after receiving the hard copies of the MSc case number 6 of 2023, was pre-engaged with some other cases.
8, I think.
Was pre-engaged with some other cases and could not prepare the appeal. Stop. The High Court, the Gauhati High Court Kohima bench was on Christmas and winter holidays with effect from 21/12/2024 to 15/1/2015. Stop. Thereafter, the learned, the counsel of the applicants prepared the appeal memo, and the draft appeal was sent to the head office, or where was it sent? On 5th February, was sent to that email, your email.
Okay, the email. It was sent to the head office as well as branch office
Was
also.
sent to the head office as well as the branch office on 5th February 2025 for vetting. Stop. Thereafter, the head office had sent the hard copy of the appeal memo after vetting to the counsel for the applicants on 24th February 2025. Stop. Subsequently, the appeal was filed on 5/3/2025. Stop. However, the registering section of the Gauhati High Court Kohima bench detected some defects in the petition, and the same had to be withdrawn and sent back to the head office and the regional office for the corrections. Stop. On 6th March 2025, the counsel for the applicant wrote to the head office stating that there are some objections/defects pointed out by the registry, due to which the appeal could not be registered. So, it was also stated in the said letter dated 6 March 2025 that the statutory deposit had also expired, and therefore to reissue the same and send to the council at the earliest. Stop. Thereafter, the fresh statutory deposit check was received on 7/4/2025, and the hard copy of the appeal memo after correction was received when?
Received on 7/4.
Was also received, along with the check.
Along with the check.
Was also received on 7/4/2025, along with the fresh statutory deposit check. Stop. It is stated that the period of limitation for filing the appeal had expired on 25/1/2025. Stop. Due to the reasons stated above, the appeal could be filed only on 2/5.
Yes.
Could be filed only on 2/5/2025, thereby causing a delay of 94 days. Stop. Learned counsel for the applicant submits that in view of the above explanations, there has been the delay has been unintentional and has been not due to willful negligence or default on the part of the applicants, and as such praise that the delay of 94 days may be condoned and the connected appeal may be heard on merit. Stop. Learned counsel Mr. Apokoner has entered appearance for the respondent/opposite party number 1 and has filed his
Number 1 and
Number
there are
1.
4 of them already.
Oh. But in your
Yes.
application is given as 1.
Yes, but in the para I've been authorized for 2, 3, and 4.
Oh, has entered appearance for respondent/opposite party number 1, 2, 3, and 4, and has filed his written objection to the application for condonation of delay. Stop. Learned counsel has submitted that the reasons given by the applicant for condonation of delay are contradictory to the records insofar it relates to the intimation by the council from Mohokchung is concerned. Inasmuch as the letter of the council at Mohokchung is dated 6/11/2024 and signed on 7/11/2024, whereas the applicant have stated that the regional whereas the applicant has stated that the intimation was sent on 4/11/2024 to the regional office at Kolkata.
Look at the applicant's counsel based at Mohokchung on receipt of the said judgment forwarded the same on the applicant's at Kolkata on 4. Yes.
That's
Four.
why
Yeah.
to Kolkata.
Yes.
As per the statement of the applicant, the regional office at Kolkata is stated to have received a copy of the award on 14/11/24 and the same was stated to have been forwarded to the head office at Mumbai on 7/11/2024. Stop.
Lordship,
These statements, yes.
that is not 14, Lordship. Although that's a typing error, Lordship.
Oh, it should have been what?
4. It should have been 04, Lordship. I apologize for that. That's a typing error. Otherwise.
No. They didn't say that that was received on 4/11. Sent on 4/11 from Mohokchung.
Yes.
Isn't it?
Received also, Lordship.
Oh, yes. Received on Kolkata.
4/11.
Forwarded the same and received at Kolkata on 4/11. No. On receipt of the judgment, sent it to Kolkata on 4/11.
Yes.
But receipt date is not given.
No, Lordship,
Receipt date is not
I
given.
made a mistake. That's what I'm saying. In my objection, I have written 14 instead of should have been 4.
No, even that is a
Yes.
mistake. It should 4 is also a mistake because 4/11 is the date on which it was sent from Kolkata.
No,
Okay.
from Mohokchung.
From Mohokchung, I mean. The applicant's counsel, on receipt of this judgment, forwarded the same to the regional office on 4/11. So that is not the date of receipt at Kolkata. That is the date on which it was sent.
Lordship, that's correct. And it was sent on only 7th.
And there is nothing said about on which date it was received at Kolkata.
Yes.
It just says regional office
It was sent
the
on the
same
7th.
on 7th.
Yes.
To Mumbai.
No receipt, no date of receipt. Application to put as it.
What did I say? The regional office situated at Kolkata is stated to have received a copy of the award on 4. Instead of 14, you just say 4. 4/11/2024. And the same was stated to have been forwarded to the head office at Mumbai on 7/11/2024. It is stated that these statements do not add up inasmuch as when the regional office at Kolkata is stated to have received the award on 14/11
Lordship, that is the
on 4/11
yes.
2024, it is not possible that a copy of the award can be forwarded on 7/11/2024. Stop. Hence, there are discrepancies in the explanation put forward by the applicants. Stop. Further, it is stated by the learned counsel for the respondents / opposite party that the panel advocate at Dimapur is stated to have received the entire file on 26/11/24. Stop. Apparently, on receipt of the file, the panel counsel panel advocate did not take up the matter diligently and without preferring the appeal diligently and has not preferred the appeal till 5/3/2025. Stop. Further, from 26/11/2024 till 5/3/2025, no sufficient cause has been shown. Stop. Further, the fact that the Gauhati High Court Kohima bench was on vacation from 21/12/24 till 15/1/2025 is no ground for condemnation as roster duties were available during the vacation and filing, if any, could have been done immediately on reopening. Stop. As per the record of the registry of this court, the office reopened on 6th January 2025. Stop. However, no such filing was done, but the applicant waited till March and allowed the time to lapse. Stop. Learned Counsel therefore submits that the applicant slash appellant has not been diligent in pursuing the matter, and therefore the present application has no merit and needs to be rejected and dismissed. Stop. This court has considered the submissions of the learned counsels and perused the next documents. Stop. The enclosures in the application of the applicants shows that the counsel at Mukokchung, the counsel of the applicants at Mukokchung had signed the letter to the regional office on 7/11/2024. Stop. Learned counsel for the applicant had stated that the same had been sent by email. You were saying, isn't it, that it is sent by email?
That might be.
That the same had been sent by email as what is this tracking? Annexure 3 is a tracking of the letter, or what is this?
No, Annexure 3 is the forwarding of this MSC case to the head office at Mumbai from Kolkata.
As the Annexure 3 to the application, which is the forwarding letter from the regional office at Kolkata to the head office Mumbai, indicates that the letter was sent to the head office on 7/11/2025. Stop. Hence, however, the applicant has not stated delete that. Therefore, the statement, the objection of the respondent that the regional office Kolkata could not have forwarded the copy of the award on 7/11/2024 when the award was received only on 4/11 was received on 4/11/2024 is misconceived inasmuch as the forwarding letter to the Mumbai head office shows that the letter from regional office Kolkata was sent to the head office at Mumbai on 7/11/2024. Stop. The court has also noted that the panel advocate at Dimapur had sent the copies of the appeal memo and connected IA for vetting by email to the head office as well as regional office by an email dated 5th February 2025. You had received when? 26/11, na?
I have received on 26.
It is seen that the learned counsel, that the counsel for the applicant had received the documents on 26/11/2024 to file the appeal before the High Court, and then the counsel was pre-engaged with other cases and could not proceed for filing the same. Thereafter, write annexure 7 to the application. The company had sent back the copies of the appeal after vetting on 24th February 2025. So, annexure 8 to the application is the objection by the registry of this court regarding the defects in the appeal memo. Stop. By annexure 9, the learned counsel had sent the email, learned counsel for the applicant had sent the email dated 6th March 2025 to the applicants / regional office / head office praying for sending back the appeal memo after correcting the objections and the defects, and also for sending the fresh statutory deposit check. Stop. Thereafter, the shipment tracking at annexure 10 shows that the vetted records along with the statutory deposit check was sent by the applicants to the council on, this is 7 April on 7th April,
On 7th April.
on 7th April 2025. Why Jorhat and not Dimapur?
No
Sent
idea.
on 7th April to the Jorhat office. Stop. And thereafter, the appeal was filed on 2/5/2025. But between 7/4/25 and 2/5 also, 1 month.
It's what? No consistent explanation there, what I've been saying. Lordship. Even after receipt of the brief, yes, the council
Even
was
after
engaged.
receiving back on 7/4, you filed only on 2/5, after a month again. I was thinking of allowing it, but there are so many unexplained gaps in between.
Lordship, that's what I wanted to place one judgment, which
Between
is
this
from the Supreme Court.
15/1/25 to 5/3, between 7/4/25 to 2/5. That also no explanation. No. This cannot be. I'm dismissing it, okay, unless you want to withdraw. Because these gaps are, it's very long gap, especially this 15/1/25 to 5/3 and 7/4 to 2/5. More than a month. After receiving back everything, you took more than a month again. 2/5 only it was filed.
Your Honor, in that eventuality, if I may seek week's time to get a confirmation, because even I also feel there are,
that is
with the leave of this
that has
honorable
nothing to do with the appellant, Lordship. This was
Confirmation for? No,
With
because
regard to
this is not the applicant's
Yes.
thing, because you have received already on 26/11. Then 15/1, when court reopened, and then the filing, the first filing, 5/3. There also that is the council, nothing to do with applicant. Then after receiving everything from the company on 7/4/25, filing on 2/5, that is also the council, not the applicant. This court has observed that there is no explanation whatsoever regarding the delay from 15/1/2025 to 5/3/2025, and also from 7/4/2025 to 2/5/2025, when the appeal was ultimately filed. Stop. This court is also of the view that the period between 15/1/25 to 5/3/25 and 7/4/25 to 2/5/2025 does not concern the applicants, but the delay has been caused during the preparation of the appeal by the council. Accordingly, this court is not inclined to allow the present application, and the same is dismissed. I was thinking of allowing it, but in between there are too many gaps.
Lordship, in that case, the order needs to be passed in the main case.
Main appeal, in view of the, in the main case, in view of the dismissal of the IA 68 of 2025, rejecting the continuation application, the MSC appeal 8 of 2025, so stands dismissed.
Lordship, there could be another IA.
No, only two, only one.
State of the
Oh, yes, yes, yes. IA 69,
That need
the
also to-
petition, this application also stands disposed of in view of the order passed in IA such and such and civil revision such and such.
Much obliged.
We follow the